Imagine stepping into a legal system where blocking someone from leaving a room for like just 5 minutes could legally carry the exact same punishment as a meticulously planned multi-state abduction.
Right.
I mean, we're talking about the death penalty or life imprisonment for a relatively trivial restraint. Welcome to the deep dive. Today, we're looking at how the model penal code fixed this just entirely broken, chaotic history of kidnapping laws.
It was a mess.
Yeah, and we're going to build the exact checklist courts use to weigh human freedom.
It really is a massive shift in how we think about justice. Because to fix a system where locking someone in a closet essentially got you life in prison, the drafters of the model penal code, the MPC, they had to build a ladder of severity.
Right.
So we are looking at Article 212 today, which is basically an integrated grading structure for kidnapping and restraint.
Okay, let's unpack this. Before we analyze the absolute most severe crimes at the top of that ladder, we need to understand the baseline. You mentioned that historical anomaly, the idea of getting life in prison for a minor restraint.
Yep.
How did the law ever get that distorted in the first place?
It really comes down to a toxic combination of broad wording and, well, severe panic. Historically, earlier kidnapping statutes had extraordinarily broad coverage paired with just incredibly severe sanctions.
Wow.
Yeah. The definition of what constituted kidnapping was so loose that prosecutors could take relatively minor everyday interferences with someone's movement and, charge them as capital offenses.
That's wild.
There was. So the drafters of Article 212 explicitly designed this new structure to remove that anomaly. They needed to separate minor restraints from truly terrifying abductions.
So think of the model penal code here like a volume dial on a stereo. To fix the system, they couldn't just have one setting that blasted at maximum volume for everything. They needed to start at a baseline.
Exactly.
So what is the very bottom rung of this ladder? What is the baseline rule for just basic unlawful restraint?
That baseline is found in Section 212.3, which covers false imprisonment. This is, like you said, the lowest volume setting.
Okay.
The black letter law states that a person commits a misdemeanor if they knowingly restrain another unlawfully, so as to interfere substantially with their liberty.
Right.
So if we break that down, a court is looking for three specific things. First, you have to act knowingly. Second, the restraint has to be unlawful. And third, it has to interfere substantially with the victim's liberty.
All right, let's put that to the test with a hypothetical case. Say you have a deeply disgruntled employee who is just furious about being passed over for a promotion.
Okay.
They decide to intentionally barricade their boss inside an office. They stack heavy filing cabinets in front of the only door and leave the boss trapped in there for several hours.
A very bad day at work.
Yeah, seriously.
Right.
So let's analyze the disgruntled employee case. First, what are the legally dispositive facts?
Well, basically, you have the intentional barricading of a boss inside an office using heavy furniture for a period of several hours.
Right. And what was the core legal issue?
The issue is whether this specific act of trapping someone in a room meets the threshold for a criminal offense.
Okay. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court would apply Section 212.3, false imprisonment, and the rule has three elements. First, the person must act knowingly. Second, they must restrain another unlawfully. And third, it must interfere substantially with their liberty.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, knowingly?
Well, the court looks at intent. The employee intentionally built a physical barricade, so they were consciously aware that placing heavy metal cabinets in front of a closed door would trap the person inside. Because they acted with full knowledge of the restraint, that first element is easily met.
Understood. Now what about the second element, unlawful restraint?
Right, so unlawful means it occurs without legal authority. The employee has absolute no legal or law enforcement authority to confine their boss. They aren't, making a lawful citizen's arrest. They're just mad about a promotion. So the court finds the restraint is entirely unlawful.
Makes sense. And the third element, substantial interference with liberty.
The court looks at the degree of the restriction. Being locked in a single room for several hours is not a mere inconvenience. It's not like someone blocking your car in a driveway for 10 minutes. It completely halts the boss's freedom to move about the world. So that substantial interference element is met.
And after analyzing all the elements, what was the court's final conclusion?
The court synthesizes all of that and holds that this meets all the elements of a misdemeanor, false imprisonment. The baseline is established.
Okay, so the volume dial is set at a misdemeanor, but obviously criminal behavior escalates.
Right.
What happens when we move from mere interference with someone's liberty to a situation that is physically dangerous or just completely subjugating? How does the law turn up the dial when the restraint introduces actual peril?
What's fascinating here is how Section 212.2, felonious restraint, bridges that gap. It takes the exact same baseline we just talked about, knowing unlawful restraint, and it elevates the punishment based on the specific conditions of the confinement.
Oh.
Yeah, it turns it into a felony of the third degree.
And what triggers that elevation?
The statute gives two specific aggravating factors. You commit felonious restraint if you knowingly and unlawfully restrain someone. And ED, you either A, expose the victim to a risk of serious bodily injury, or B, hold another in a condition of involuntary servitude.
Wow. Okay, let's look at those. Suppose someone unlawfully ties up a business rival and leaves them suspended by a rope over a pit of venomous snakes. Or, alternatively, locks them in an underground bunker and forces them to manually grind grain for survival.
Getting very cinematic here.
I know, very James Bond villain, but let's analyze the snake pit and bunker cases. First, what are the legally dispositive facts?
The core facts are unlawfully tying someone up over venomous snakes, or, in the second scenario, locking them in a bunker and coercing them into forced manual labor for survival.
And what was the core legal issue?
The issue is whether these specific extreme conditions elevate a basic restraint into a more severe felony.
Right. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applies Section 212.2, felonious restraint. The rule has three elements. First, knowingly. Second, restrains another unlawfully. And third, either exposes the victim to risk of serious bodily injury or holds them in a condition of involuntary servitude.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first two baseline elements, knowingly and unlawfully?
The court confirms these are met exactly as they were in the previous section. Tying someone up or locking them in a bunker is a knowing act done without legal authority, so the baseline is cleared.
Understood. Now what about the crucial third element, the elevating factors of serious bodily injury or involuntary servitude?
This is where the mini-IRS shifts. For the snake pit, the court finds that a fraying rope or a snake bite clearly introduces an immediate lethal peril, satisfying the risk of serious bodily injury requirement. For the bunker, forcing labor under confinement and threat of starvation perfectly satisfies the involuntary servitude requirement.
And after analyzing all the elements, what was the court's final conclusion?
The court concludes that because these aggravating factors are present, they elevate the crime from a baseline misdemeanor straight to a third-degree felony.
So we've gone from a misdemeanor for locking a door to a third-degree felony for adding danger or slavery, but we still haven't reached the absolute top of the ladder.
No, we haven't.
Here's where it gets really interesting. How does the Model Penal Code define the ultimate, most serious form of unlawful restraint kidnapping without falling back into that historical trap of punishing trivial stuff too harshly?
All right, so Section 212.1 is the apex offense, kidnapping. And to avoid that trap, the drafters made the rule incredibly precise. It requires a specific physical act, what lawyers call the actus reus, and a specific state of mind.
So what about the physical act itself, the actus reus? What does a person actually have to do?
For the act of kidnapping, a person must do one of two things. First, they unlawfully remove another person from their place of residence or business, or a substantial distance from the vicinity where they are found. Or second, they unlawfully confine another for a substantial period in a place of isolation.
Notice you use the word unlawfully again there, but we are talking about extreme crimes now. What does unlawful specifically mean in this context?
Good catch. There's a sub-rule. A removal or confinement is only unlawful if it is accomplished by force, threat, or deception.
Okay, so force, threat, or deception.
Mostly, yes. But crucially, if the victim is under the age of 14 or is legally incompetent, the act is automatically unlawful if it is accomplished without the consent of a parent or guardian.
Ah, okay. Let's analyze two contrasting cases to test this. In scenario 1, an attacker physically drags a business owner out of their shop. In scenario 2, an adult simply uses deception to lure a 13-year-old away from a park without their parents' permission. First, what are the legally dispositive facts?
The facts are either using physical force to remove a shop owner from their business or using a lie to remove a 13-year-old from a park without parental consent.
And what was the core legal issue?
The issue is whether these different methods satisfy the physical act and the unlawful means required for kidnapping.
Right. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applies Section 212.1. The actus reus rule has two main elements. First, unlawfully removing another from a residence, business, or substantial distance, or confining them in isolation. Second, the sub-rule element. The means must be unlawful, meaning by force, threat, deception, or without parental consent for a minor under 14.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, removal or confinement?
The court analyzes the movement. Dragging the owner out of the shop hits the explicit language of removing someone from their place of business. Luring the child away from the park constitutes removing them a substantial distance from the vicinity. So the movement element is met for both.
Understood. Now, what about the second element, unlawful means?
The court applies the sub-rule. For the business owner, the physical violence clearly qualifies as force. For the 13-year-old, lying about a puppy is deception. But more importantly, because the child is under 14, the strict lack of parental consent rule is triggered. Both methods satisfy the unlawful element.
And after analyzing all the elements, what was the court's final conclusion?
The court concludes that the actus reus for kidnapping is fully met in both scenarios.
But simply moving someone or isolating them isn't enough to trigger the harshest penalties, is it? We have to look at the state of mind.
Exactly. The law demands we look into the perpetrator's mind to find their ultimate goal.
So what does this all mean for the perpetrator's intent?
This is the mens rea of kidnapping. The act must be done with one of four specific purposes. Purpose A is to hold for ransom or reward, or as a shield or hostage.
Okay.
Purpose B is to facilitate a felony or flight. Purpose C is to inflict bodily injury or to terrorize. And Purpose D is to interfere with the performance of any governmental or political function.
And what's the grading for this?
Kidnapping is a first-degree felony. It's the apex crime. However, and this is a big man, however, there is a built-in mitigation rule. If the actor voluntarily releases the victim alive and in a safe place prior to trial, it drops to a second-degree felony.
Let's analyze the political extremist case. Say an extremist forcibly kidnaps a local mayor, locks them in a soundproof basement to stop them from signing a bill, but weeks later feels guilty and drops the unhurt mayor at a hospital before any trial. First, what are the legally dispositive facts?
The facts are the isolation of a mayor to stop a bill signing, followed by a voluntary safe release at a hospital prior to trial.
And what was the core legal issue?
The issue is whether the intent meets the kidnapping threshold, and whether the safe release rule applies to mitigate the charge.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applies the mens rea and grading rules of Section 212.1. The elements are, first, one of the four severe purposes, such as interfering with a governmental function, and second, the mitigation element, requiring voluntary release alive in a safe place prior to trial.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the specific purpose?
The court examines the reason for the confinement. The intent to stop the mayor from signing a bill perfectly satisfies the element of interfering with a governmental or political function, so the severe purpose is established.
Understood. Now what about the second element, the mitigation rule?
The court checks the conditions. The release was voluntary due to guilt. The victim was alive and unhurt. A hospital is a definitively safe place, and it occurred prior to trial. So the mitigation element is entirely met.
And after analyzing all the elements, what was the court's final conclusion?
The court synthesizes this and holds the perpetrator guilty of kidnapping, but graded as a second-degree felony due to the safe release.
Wow, that's incredibly precise.
It really is. If we connect this to the bigger picture, you can synthesize this entire module into a step-by-step diagnostic checklist for an exam. Step 1. Was someone unlawfully restrained? If yes, proceed.
Got it.
Step 2. Was it merely a substantial interference with liberty? If so, your diagnostic is false imprisonment, a misdemeanor.
Okay, and then step 3.
Right. Step 3. Did the restraint expose them to risk of serious injury or involuntary servitude? That diagnostic is felonious restraint, a third-degree felony.
Elevating the danger.
Exactly. Step 4. Was there substantial removal or isolation, PLUS, one of the four severe purposes, like ransom or political interference? That diagnostic is kidnapping, a first-degree felony.
And the final step?
Step 5. If kidnapping, did the actor voluntarily release the victim alive and safe before trial? That diagnostic mitigates it to a second-degree felony.
That checklist is an incredibly powerful tool. Thank you for joining us on this deep dive. We've walked through how the model penal code uses precision to fix a chaotic history, but I want to leave you with a final provocative thought.
I like these.
The statute requires removal a substantial distance or confinement for a substantial period. But what exactly does substantial mean?
Good question.
Does moving someone from the front of a bank to the back vault count as a substantial distance, or is it just part of the robbery? The MPC leaves that precise line up to interpretation, and it's up to future lawyers to argue where it is drawn. Thanks for listening, and we'll see you next time.